So we got deeds, taxes, and fees. The seller shall pay for preparation of a deed and other documents necessary to perform seller's obligation. So this is just saying the sellers have stuff that they need to pay for: the deed, the taxes, and the fees. So like I said before, a lot of this stuff is going to be prorated, but they have some responsibilities too as a seller. And this portion right here is the seller, the agreement to pay buyer's expenses. So this is the buyer's closing costs. So we would state here if the sellers are agreeing to give us any concessions. So if that's $1,000, that's that. If that's $5,000, whatever it is, if we know that prior, if it's listed in the MLS that, hey, they are gonna pay XYZ, sometimes it is stated. If not, this is what we're offering. We're asking for the sellers to pay $1,000 towards our buyer's closing costs. Or, again, a competitive market, we put 0 in here. Because it's just that time, you all, when it's a seller's market, we're asking the sellers to do the least as possible, because there's going to be another person, a party that is looking for that home if there's multiple offers on that, and they might not be asking the seller to pay for anything. So if we put a hefty $5,000 in here, and then the next contract comes with they don't want the seller to pay anything, of course they're going to take that offer over yours. So this is the section where we are going to put in here what we are requesting or asking of the sellers to pay to help out to pay towards your closing costs. Okay, this note says the parties should review the FHA VA addendum prior to entering an amount in paragraph 8. Certain FHA VA lenders and inspection costs cannot be paid by the buyer at the settlement, and the amount of these should be included in the above. So we just need to check out if there's any restrictions that the buyer can't pay. If they're on some type of program and they can't pay for this or that, or even receive it, we need to make sure with the FHA and VA addendum that we're in compliance with that. And we will find that out with your lender. We're in the Owners Association fees, charges. The seller shall pay any charges by an association or management company vendor as agent of the association under the paragraph contract. So any fees that's due prior to closing is the seller's responsibility. Payment of settlement, payment of special assessments. Sellers shall pay in full at settlement all special assessments that are approved prior to the settlement. So we've talked about that before. So it's their responsibility. If it's been approved before that date, it is the seller's responsibility, and it will come out of their proceeds. Late listing penalties. All property tax late listing penalties, if any, shall be paid by the seller. So if there's any type of late listing penalties, that is not the buyer's responsibility, that is the seller's. Okay, negotiated repair improvements. Negotiated repair improvements shall be made in a good and workmanlike manner, and buyers shall have the right to verify. So anything that has been done, and when we put in that due diligence repair request and we ask them to do XYZ, they agree. We need to receive all invoices, and it needs to be done in good manner. Sometimes we require a general contractor, and sometimes we don't. Certain things doesn't require a general contractor, but it just needs to be done in a good and workmanlike manner. And so this section here is the home warranty. This is stating that there's no home warranty that's going to be provided by the seller. This is if we're asking the buyer to obtain a 1-year warranty, and then we're asking for the amount. We're going to say, hey, would you pay for a 1-year warranty for us for $550? And this last one is just stating that the seller already has a 1-year warranty from whatever company, and this is the amount that has that's been paid on the particular or the amount of the actual warranty. So they already have one. So you were going to just transfer yours into that, your name into that warranty. So let's check out this note. It says home warranties typically have limitations and conditions to coverage. Refer specific questions to the home warranty company. So if the home, the seller is providing a home warranty, we need to get in contact with that home warranty with any specifics or questions about the coverage. So here we are, seller breach of contract. See paragraph 23 for buyer's remedies in the event of the breach of contract. So the charges by owners association, responsibility for payment of charges by owner association or management company vendor as agent of the association shall be allocated between buyer and seller as follows. And it's going to describe to you the seller shall pay, and it goes into these different things of what the seller will pay. The fees incurred by the seller in completing the residential property and owner association disclosure statement, and the resale of the other certificates related to a proposed sale of the property. The fees required for confirming the seller's account. So there's fees that the association will charge the seller to complete the sale of this home. Any fees charged for transferring or updating the ownership records of this association, and any fees other than those fees specifically required to be paid by the buyer under the paragraph 9. So, and this is stating what the buyer shall pay. The charges from providing information required by the buyer's lender, the charges for working capital, contributions, membership fees, or charges imposed for the buyer's use of the common elements and or services provided to the buyer in connection with the buyer taking possession of the property, such as move-in fees and charges, or determine restriction covenant compliances. So this is your obligation. So this section right here is going to talk about the proration and adjustments. Unless otherwise agreed, the following items shall be prorated, with the sellers responsible for the prorated amounts of any taxes and dues through the date of settlement, and the sellers entitled to the amount of the prorated rents. So in other words, we have stated that before. The seller is going to be responsible for the time that they own the home. The buyers are going to be responsible for the time after the closing. So any prorations of the HOA fees, taxes, and anything like that, there's going to be a proration of it. Initials, we are understanding what has been stated prior to. Additional items that's going to be prorated: the taxes on the real property, taxes on personal property, any rents, and any dues to the association. Any dues that is due to the association. So here we are in 11, the condition of the property, risk of loss. Let's highlight this. The condition of the property at settlement. If the property is not in substantially the same or better condition at closing as on the date of the offer, reasonable wear and tear accepted, buyer may terminate this contract by written notice delivered to the seller, and the due diligence fee and earnest money shall be refunded to the buyer. If the property is not in such condition and the buyer is not does not elect to terminate this contract, the buyer shall be entitled to receive it in addition to the property, the proceeds of any insurance claim filed by seller on account of any damage or destruction to the property. So this is said, this is why it's important to do a final walkthrough, because we need to know that this home is in the same condition that we've seen it in. Hey, if it isn't, we can terminate this contract and receive the due diligence money back as well. This is, again, another breach on the seller side. The seller has responsibilities. So if anything is being done on this property, it needs to be taken care of. The seller needs to take care of any issues that has happened during this transaction, because we are purchasing this home from what we've seen previously. So it is the seller's responsibility to take care of all any damages. The risk of loss. The risk of loss or damage by fire or other casualties prior to closing shall be upon the seller. The seller is advised not to cancel existing insurance on the property until after confirming recordation of the deed. So this home needs to always be insured by the seller. The seller is not to cancel the insurance until the deed is recorded. This is what this is stating. Okay, so now we're on the delay settlement closing. And what this is saying, that if one party is ready and the other party is not, we have 7 days, and which is basically if the seller, of course, is ready to ready to sell the home, and the buyer, for whatever reason, there's a delay. We have 7 days of the settlement date, including any amended settlement date agreed to in writing by the parties. Then the delaying party shall be in breach, and the non-delaying party may terminate the contract and shall be entitled to enforce any remedies available to such party under this contract for the breach. So it is imperative, buyers, that we get you pre-approved, get all the necessary documents in there so we can get a clear to close, because whatever that date is that we specify on that particular contract that we're going to close on the 20th, we have until the 27th. After that, we are in breach, and again, you will be at risk of, you will lose your due diligence and your earnest money deposit. Okay, possessions. Possessions including all means of access to the property and transferable amenities and services, keys including mailbox keys, codes, all of that stuff. We need to have those items there, left at the property, left at the attorney's. However, we need access, and we need those shall be delivered upon closing as defined in paragraph 1. Now, this is stating here in this section, if we're going to, the buyer is going to possess the property before closing, a seller possession after closing, and possession is subject to the rights of tenants and stuff like that. So this is stating how we're going to handle this. At closing, the buyers, they're going to possess it then. If there is a seller, like they're going to rent back, so you're purchasing the home, but the sellers need to be their military, and their items is not going to be picked up for 5 days. So we need to have an addendum there put in place. They're basically renting the house back. And it's also, this portion down here is the possession is subject to the rights of tenants. The parties should attach either additional provisions addendum or the vacational rental addendum, just letting it be known, okay, that we're selling this house. The renters know that we're selling it, but their lease is not up until such and so date. So we need to have all of those things in place to make sure that we know that when the buyer is that the buyer is aware of all of this. So they know that the closing was on the 20th, but now they can't move in. They didn't know that they had the tenants in there, and the tenants is not due to move out until the 25th. So we just need to make sure that this is taken care of, and we are all aware, all parties are aware of these conditions. And right here is 14 is an addenda. Check all the standard addendas that may be a part of this contract. So we're going to check on here. We're going to check all addendums that's attached to this contract in this part. So everything that's attached. So usually you're going to see just typically the additional provisions addendum. We're going to have the FHA VA if it's a FHA, or if it's a VA financing. And that's pretty much the things that's going to be attached here. This identify other attorney or party drafted addendas. This could be in the case of, in that hot market 2.5 years ago when it was a seller market, we had an appraisal addendum where the buyers were agreeing to pay XYZ amount over the appraised value. So we would need to attach that addenda with this contract. So let's see what this note is saying. Under the North Carolina law, real estate brokers are not prohibited to draft any addenda. So we can't just draft up nothing. We have draft up an addenda like that. We have to make sure that it is drafted by a licensed North Carolina attorney. So number 15, assignments. This contract may not be assigned without the written consent of all parties except in connection with a tax-deferred exchange. But if assigned by agreement, then this contract shall be binding on the assignee and the assignee's heirs and successors. So this is not an assigned contract, but assignment. But if it is, then it's whoever is the assignee, they're responsible, or their successors are responsible for everything that's in this contract. 16, tax deferred exchange. In the event the buyer or the seller desires to effect a tax deferred exchange in connection with the conveyance of the property, the buyer and the seller agree to cooperate in effecting such exchange provided, however, that the exchanging party shall be responsible for the additional costs associated with such exchange, and provided further that a non-exchanging party shall not assume any additional liability with respect to such tax deferred exchange. The buyer and the seller shall execute such additional documents, including assignments of the contract in connection therewith, at no cost to the non-exchanging party, as shall be required to give effect to this provision. So any tax deferred exchange between the two parties, they need to execute whatever documents that needs to be executed to make this binding. Initials are needed.